Good afternoon. I'm Ken Randall, the founder and president of iLaw, which is part of Barbary. And along with my co-host, Dean Kellye Testy, we're delighted to welcome you to the May program of Live with Kellye and Ken. Kellye, of course, is the president and CEO of LSAC. We know what a phenomenal job she's done the last few months getting LSAT Flex up and running. So Kellye, as always, as we said last month, we really appreciate all that you do, your leadership of the Law School Admission Council. We also want to say to our panelists, great word of thanks, great experts on disability law. We want to say to all of our viewers, we hope that you and yours are well and safe during this time. And we know you have a lot of demands on you, and yet we have 1,800 people who have registered for the next hour. So thanks for being with us. As with previous programs, we're going to continue our focus on the core theme of equity in education. But today, we're going to focus particularly on accommodations for individuals with challenges, disabilities, the accommodations that we should be making in legal education, accessibility, and then, of course, extending that out into legal careers and into the legal profession. And we know that COVID-19 actually provides a unique and special context for these issues, which really can be exacerbated by the move to remote learning. So without further ado, I'm going to introduce to you in alphabetical order our four panelists. Again, panelists, thank you for being with us. Starting with Dr. Peter Blanck, who is up in Syracuse, university professor, chairman of the Burton Blatt Institute, which focuses on global issues involving disability issues. Dr. Blanck, great to have you with us.
Thank you.
Secondly, Leanne Shank, who is a senior vice president and general counsel at the Law School Admission Council. For 20 years before that, she served as general counsel at Washington and Lee University, and she's dealt extensively with disability issues. Leanne, great to have you with us.
Thank you, Ken.
Then we have two law school deans. Again, in alphabetical order, we have Michael Waterstone, who is the dean at Loyola Law School in Los Angeles. He's an expert in disability law, teaches disability law, has a leading case book in disability law, and has served the ABA, the state of California, and the AALS on disability law issues. And finally, Dean Ron Weich. Ron, I was worried about pronouncing your last name, and I messed up on your first name. Ron Weich, who's the dean at the University of Baltimore. Ron has a distinguished career before becoming a dean, worked in the Department of Justice, was an assistant U.S. Attorney General, an extensive background on the Hill. I know sharing your insights about the legislative process with us, Ron, will be helpful. So wonderful to have you with us, Ron.
Thank you.
Kellye, I'm going to turn it over to you to start some questioning, please.
All right, Ken, I'll be glad to do that. And I want to join you in thanking everyone for joining us today, and especially thanking our panel. This topic is a critical one. And as we've seen from COVID, issues of inequality are even more in the forefront. And so I'm thrilled we can talk about this topic of accessibility in the law today, and really appreciate the panelists joining us. We also want to say from the Law School Admission Council that our hearts go out to everyone that's been so affected by this pandemic. And we want to make sure you know that we're always there to help you along your enrollment journey. So if there's anything you need, know you can count on us and be in touch, and we'll make sure to help that journey continue. Well, I want to start, Peter, with you. You have done such amazing work at Syracuse and throughout your career. And the center's now doing some path-breaking research on enhancing opportunities in the profession for people with disabilities. So I thought it would be wonderful to ask you to start by, giving us a sense of some of the key areas you're working on right now. What are some of the main focus areas? And I'll turn it to you to share those thoughts today as we get started.
Well, thank you, first of all, at this difficult time for everybody for having this conversation. I'm very honored to participate with you guys. 30 years ago, the Americans with Disabilities Act was passed this summer. And about 25 years ago, I was an expert witness in a federal district court in Boston in a case called Guckenberger versus Boston University, which was among the first cases that looked at issues of learning disability and non-visible disabilities brought by law students and undergraduates to really try to understand how this new law, this Americans with Disabilities Act, would affect the ways in which they had access to education. That was a success for the law students. It was a success for Boston University School of Law, because I think all boats were raised as a result of that. 30 years later, I'm directing, as you said, quite a large institute called the Burton Blatt Institute. We're doing about $60 million in projects with offices in Atlanta and New York City and Washington, New York, soon to open California. And one of the core areas we focused on is basically inclusion, diversity of people with disabilities and others with multiple minority characteristics into the legal profession, into the professions, and of course, into the world of work. About 2 years ago, the American Bar Association approached me and my colleagues and said they had done and commissioned a number of studies on what is called implicit bias, or sort of unintentional or unconscious bias, particularly around race and gender. And they were very interested in, given the work that we have been working on at the Burton Blatt Institute, in understanding that concept as relative to persons and students with disabilities in the legal profession, broadly defined. It turns out, in probably not the most delicate way, I said, well, implicit bias, what about express bias? Let's take a look at, both sides of the coin. And the ABA commissioned us, and soon thereafter, their division called SOGI, the Sexual Orientation and Gender Identity Commission, became very interested as well, because there had not been a study of these sorts of issues regarding the LGBTQ community. So with this concept in mind, we created a blue ribbon advisory panel with deans and experts like yourselves to build a study, an online study, to look at these issues, particularly focused on people with multiple minority identities, disability and LGB included, and what might be called from an intersectional perspective. And very briefly, because I'm of course interested in hearing what the panelists say, as the law professor, no longer the dean on this panel, I have not perished, I'm still publishing. So 3 articles are in the works. One is coming out next month in the University of District of Columbia Law Review, based on a speech I gave there. And essentially, after a lot of scientific work, validity, underlying the questions, pilot testing them, and so forth, we approached 200,000 lawyers across the country in all walks of life, all phases of their career, from just out of law school, all backgrounds, public and private, from the largest firms down to the smallest firms, from every state in the United States, including lawyers working overseas, because we were very interested in what Michael will talk more about, Dean Waterstone, this emerging pipeline into the legal profession. And ironically, now we have a natural experiment, what a scientist would call almost a quasi-experiment, because our next round of surveys are going out in the fall, and our main treatment variable will be, sadly, a health and economic emergency, i.e. COVID-19, and how that will affect the legal profession. So in a nutshell, we have about 3,500 responses that we've begun to analyze, who've responded to the complete survey, qualitative, quantitative information, more than half women, high proportion, about 16% of individuals in the LGBTQ community. Why? Because we oversampled. 25% in the disability community, and a little lesser in people who identify with disability, all sorts of disabilities, which we could talk about. And if you had asked me for perhaps three things to finish and summarize what we're learning so far, number one has to be, perhaps I was naive, but an extraordinarily high experience of stress and mental health issues faced particularly by people with multiple minority identities in the legal profession, which is probably of no surprise to anybody on this panel or anybody listening in. But the stories, both qualitatively and the quantitative information, were kind of off the charts. Number two, if you'd asked me for general themes, I would look at the accommodation issue, which we are talking about here today. The short answer on that, very interestingly, which supports our prior research, is that it's not just people with disabilities who are seeking accommodations. It's a lot of people who want to work flexibly, who want different technologies, who are returning from work for injuries, who have family members with disabilities, and typically they're low-cost accommodations requested, and a very high proportion, more than 3/4, have been granted across the studies we've looked at it and in this study. Interestingly, we're now in a new norm, a new normal, where telecommuting is the norm. And in the past, of course, that was a, quote, accommodation. So we're going to be very interested to look at the type and costs of accommodations as the whole legal profession goes through, on one level, what might be a real estate transformation in terms of expensive space and conference rooms in law firms, and allowing people individualized approaches as appropriate to work. The third theme, and then I'll be quiet because I want to learn with you guys, is what I've proposed in this typical publish and not perish mode. Of course, a law professor has to have a little bit of a model or some conceptual thinking, was an extension of traditional thinking about diversity and inclusion to include as a natural element a culture of accommodation, an organizational approach to thinking about individual flexibility that allows for diverse and inclusive talent to participate in an organization, whether it's a law school, whether it's a not-for-profit, which we study, whether it's a governmental organization, whether it's the judges' chambers, which we study. And we find in our research, in a nutshell, trimming down several years' worth of work into a glib statement, that those organizations that tend to be perceived and approach this culture of accommodation tend to have greater employee satisfaction, retention, and productivity. So that's about several years' worth of work in 3 or 4 minutes of overview. I hope it stimulates some discussion. The papers will be available freely and online. The first paper will be out next month, followed by a paper in a peer-reviewed journal just on accommodations, followed by a special issue. I was greatly honored to be invited to write an article for the American Journal of Law and Medicine on the future of the legal profession and issues in discrimination and bias. And that paper will come out later this year, and there'll be commentators from the disability community, from the LGBT community, and other communities about, hopefully, what we're trying to contribute to this dialogue. So thank you, guys, and I'm very interested in hearing what you have to say as well.
Peter, thank you for a really rich set of comments and all that good work you're doing. You know, I love the way that you make the point that creating this kind of a culture where every person can thrive and work flexibly, it's not only the right thing to do, it means people are happier doing their work, doing work better. We need all those voices in law. So thank you for all that you're doing. And Michael, I want to turn to you. You're a busy dean there of Loyola, but I know that you've done both a lot of research yourself in this area, and you also have the terrific Coelho Center there. And so I want to turn to you to hear a little bit about the issues you're focusing upon now.
Thank you, Kellye, and thank you, Ken. I want to take a moment and thank both of you for allowing us a platform to talk about this issue. I think so much of what we can do as leaders of organizations is create space for conversations to occur, and I'm really grateful that you are giving this one this time at this moment. As we talked about in the opening comments, we're experiencing, a global pandemic and massive disruption in everyone's personal and professional lives. But what we also know is that is going to lay bare every vulnerability and inequality that exists both in legal education, but also in society. And that burden is not necessarily evenly distributed. So this is a really important conversation, and I'm grateful to both of you to creating space for it. I think I drew the short straw having to go after Peter. Peter's one of my, friends and really mentors and heroes. I was a baby lawyer at a law firm, and there was a lawyer who was a partner that I worked with there named Chuck Siegel, and Chuck and Peter were working. They had a contract for a book, and Chuck asked me if I would help, and I assumed that they were just looking for someone to check footnotes or something. And, I enthusiastically agreed. And a couple weeks or months in, Peter asked me to be a full author on that book. And just that act of generosity of spirit has always stayed with me. And I'm just grateful for Peter's many contributions in this field. So this is such an important issue. It's more important now than it's ever been. Let me kind of keep my comments brief so we have more time for dialogue and discussion. Certainly at Loyola Law School, at Loyola Marymount University, and so many of the colleges and universities that we serve, this is an issue which is only growing and taking on more importance. As we as a society get better at educating students K through 12, that means more students with disabilities are going to college, should mean more students with disabilities are going to law school. So in a sense, it's part of a move toward progress in the world. And our job as educators and leaders is to be responsive, embracing, and welcoming of it. Kellye, as you mentioned, we do have the Coelho Center at Loyola Law School and Loyola Marymount University. That is named after Tony Coelho, who was one of the architects of the Americans with Disabilities Act. At the Coelho Center, we are focused on a number of things that I'll just briefly touch on. Certainly, we try to take an interdisciplinary approach in all that we do. If our mission is to improve the lives of people with disabilities and work toward their full inclusion into society, those challenges don't fall in law buckets or engineering buckets or communication buckets. They really are tied together. So we want to constantly challenge ourselves to work across the different parts of the university. Being in Los Angeles, we have a focus on entertainment and portrayals of individuals with disabilities in the media. We are focused on issues relating to polling and voting access, particularly as we roll into the 2020 election season. And we always have an eye on technology, knowing that that is such an important force in all of our lives, not just for individuals with disabilities. We are engaged in a pipeline program that is focused on creating a more robust pipeline of college students with disabilities with an interest in law school. And hopefully I'll get a chance to talk about that a little bit later. But I wanted to acknowledge, if it's the elephant in the room or whatever the metaphor is, that all of us in legal education exist in a moment where things are not normal. We are, existing in an environment that none of us really expected. We are leveraging new technologies in the most nimble ways that we can. And as we do that, we need to challenge ourselves to be accommodating the needs of students with disabilities. And as Peter said, now's the time to show our muscle on that culture of inclusiveness, that we all value. So certainly, as we have all transitioned into emergency remote instruction, we know that that is one of those areas where challenges for students with disabilities are not necessarily equally distributed. Students with disabilities face an increased risk of bad internet connections. This is particularly challenging for students who have low vision or blindness. Students with attention deficit disorders are having a harder time right now focusing on classes and staying focused online. Students with anxiety or underlying mental health challenges are struggling through these unprecedented issues facing the world and how it's impacting their ability to focus and learn. Students with disabilities who receive accommodations are especially concerned about exams at home and remote proctoring options. And there are no easy or clean answers to any of these questions, but it is important that we address them. It is important that we talk about them, and it's important that we work across our communities to set the value statement that we're not ignoring these challenges in this difficult time, and indeed we're being as creative as possible to try to work toward solutions. So with that, I'll stop for now, but really look forward to our continued conversation.
Thank you so much, Michael, for your leadership. It's so needed and appreciated. Ron, I want to turn this to you. Like Michael, you're a busy dean, and I know that you've done a lot at your school and in legal education to advocate for accessibility. What are some of the things you're doing, and how do you think it's going overall for legal education in this realm?
Thank you, Kellye, and thank you, Ken, for inviting me to participate in this very important discussion. This issue has a personal dimension for me. Ken was nice to mention my experience in Washington. Before I was a dean, I was a practicing lawyer and worked in a number of roles, but as a young lawyer, I worked in the Senate for Senator Ted Kennedy, who was a leading sponsor of the Americans with Disabilities Act, and I was there when the act passed. Through my time in Washington, including when I was at the Justice Department and at a time when this issue was a high priority, I saw the incredible progress in the rights, civil rights of individuals with disabilities. I saw individuals in the legal profession who made such a mark, everyone from Chuck Ruff, President Clinton's White House counsel, who defended President Clinton on the Senate floor from a wheelchair, and David Tatel, who's a leading judge on the DC Circuit, and individuals with less visible and invisible challenges who are important leading members of our profession. So as a law school dean, I know Michael and I shared this sense of responsibility to make sure that law school is open and accessible to individuals with disabilities so that the profession benefits from all they have to offer. I think, Kellye, in response to your question, the task before law school deans and the legal education industry in particular is how to ensure appropriate accommodations that are consistent with the fundamental nature of legal education. Of course, the ADA itself speaks of reasonable accommodations. The case law then says that there needs to be consistency with the nature of the educational program. And in the case of legal education, that can be challenging because law school is intense. It's meant to build resiliency and help students prepare for the bar exam in the first instance, which is a high-pressure timed exam, and for the legal profession, which has all kinds of intense challenges every day. So we need to find ways in which to provide the educational opportunity for people, but make sure that we're doing all we can to provide them, to prepare them for the bar and for the profession. And I think the key is to have an interactive, individualized process for considering accommodations. There's no one-size-fits-all. There are different students with different kinds of challenges, and then there are different kinds of law school classes. And what might be an appropriate accommodation in a large torts class is quite different than the accommodation that would be appropriate in a clinic setting or a seminar or a litigation process class. And so we need to work with students and make sure that we're counseling them to make sure that they are obtaining the accommodations that they need to succeed and compete on an even plane, but are not in a position where they're getting, automatic double time, for example, on exams, when that's not going to be offered to them on the bar, and they're not going to have that kind of luxury when they're in the profession. So I think all schools are working on this. We have many more students who are seeking accommodations, as my colleagues have spoken previously. Michael and Peter both spoke about the pipeline, and it's wonderful that there's an expanding pipeline of individuals with disabilities coming from high school and college to law school. So as there were more individuals requesting accommodations, we're learning how best to accommodate those individuals to ensure that the education is available and make sure that we're doing our job as legal educators to prepare the next generation of highly effective, successful lawyers.
Thank you so much, Ron. And it's great to hear how really between all of you, you're working on almost every aspect of the pipeline, and I'm going to hear from Leanne in a minute about that, pre-law and into admission piece of that. But that's really so critical to unite that learning journey and make sure that from pre-law into law school and all the way through practice, we're thinking about this holistically and supporting those students all the way along. I do want to say to our viewers that we're answering some of your questions as best we can while the show's going on. One of my staff members is helping with that. We'll also take some questions toward the end of the program today live. And then I just want to let you know too that any of those we don't get to, we try and follow up on. And some of you are asking if you can watch this later. And yes, you can. It's posted both at lsac.org and it's also posted at iLaw's website. So you can certainly have access to it more than just here. So Leanne, let me turn to you. I want to welcome you and let you know that you've done a really wonderful job helping to connect LSAC to a lot of the disability rights community. And I want to hear about some of the things that you think candidates ought to know about how LSAC is welcoming them and the kinds of things we've put in place to make sure that we're addressing the full range of openness and accessibility. I think you're on mute, Leanne.
Okay. Is that working now?
Yes.
Perfect. Okay, thank you, Kellye. So I'm really excited to be part of this panel. Disability rights has become a personal and professional compassion for me. And so I'm excited to be on this a panel with very esteemed guests. So one of the reasons I was attracted to become part of LSAC under Kellye's leadership several years ago was her commitment to diversity and inclusivity, but being especially interested in outreach, support, and pipeline building for individuals with disabilities to the law school and the legal profession. And lawyers, especially disabled lawyers, are needed now more than ever to support equity, justice, and the rule of law in a diverse global world that is so dramatically challenged at this time. And accommodating those individuals with disabilities and advocating for disability rights is key to LSAC's mission of promoting access and equity in the legal profession. So as I began my work at LSAC several years ago, I learned that LSAC was not viewed so favorably in various disability communities. I heard, as I started trying to do some outreach in this area, that LSAC just didn't quite get it. So having heard that, I proceeded very quickly under Kellye's support, leadership, encouragement to conduct a very detailed review and learn about the challenges that individuals may experience in their journey to law school through starting with the LSAT and then in their admissions journey. We conducted a detailed review of every process, procedure, and policy that applied to candidates who requested accommodations for the LSAT from the time they registered through their test and their admission to law school. We left no stone unturned, and we wanted to understand whether any of our policies and procedures placed burdens on test candidates with disabilities that could be eliminated or changed. And as importantly, we wanted to explore how we could be more supportive and meaningfully responsive to these individuals as they prepare to take the test, attend law school, and then move on to the profession. This diligence exercise we went through could form a blueprint for law schools that they could use to examine their policies and practices in addressing requests for accommodation and in supporting their students with disabilities. More disabled students are entering law school these days, and law schools really have to be prepared to deal with, support, and encourage their participation in your programs. Law schools need to understand the challenges facing these students and determine how their policies and practices could be modified to help reduce unnecessary challenges. And LSAC is really here to help in planning for interested member law schools. So as a result of our initial review, we did a number of things. We created a dedicated director of legal operations who was overseeing all procedures and accommodated testing to bring cohesion to all of our day-to-day operations. We created a specialized team of accommodated candidate support staff who are dedicated and specifically trained to address accommodated test taker questions and concerns and to smooth the process as these individuals prepare for the LSAT. We added a dedicated phone bank for accommodated test takers to be placed directly to these trained staff members who could understand their questions, understand their challenges, their types of accommodations, and deal compassionately with their concerns. And this staff is incredibly dedicated to supporting these candidates. Separate from our accommodated testing area, we created a corporate accessibility department with experts in accessible web design and document conversion to work hand in hand with our products and services teams to be certain that anything we build begins with compliant designs for web, digital, document accessibility. And we're also creating an internal disability advisory group that will help oversee this effort. So finally, I wanted to mention our goal is not only to use our best efforts to be compliant with applicable standards, but to see that our products and services are designed for people of all abilities. Going back to Peter's and Michael's comments about the culture of accommodation. We've consulted with a number of organizations, including the Institute for Human-Centered Design, which is an organization whose mission is to advance the role of design in expanding opportunities and experiences for people of all abilities through excellent design, as we sought to input on our test site, our website, its content, our digital LSAT and other products to see not only that they were designed to be user-friendly but to be user-friendly to shape and foster social equity. I know many law schools have centralized disability offices, and I encourage them to have individuals dedicated to addressing some of these unique accommodation issues that Michael just pointed out, so that law students can feel as though they are being supported through what is always a challenging time for them in their journey to the profession. So we're here again at LSAC to help our member schools with those efforts.
Thank you so much, Leanne. And I know that I speak for both of us in saying that we so appreciate the collaboration of so many in this community that have, really joined hands with us to help us learn and help us give the best service to candidates and to schools. And that kind of joint work is really important. And I think all of us are going to benefit from that going forward. Ron, I want to come back to you and I had a question for you, but I'm going to edit it just a little bit based on some questions I see coming in. And that is that the candidates are wondering whether, in your opinion, the schools are really welcoming of diversity, and also whether there's opportunities programmatically that schools provide for students who want to pursue work in disability rights once they graduate. So any of your thoughts just about how you or schools generally are welcoming diverse students, and then opportunities to work for these rights on the other end once they're graduates?
Well, thanks, Kelly. I mean, one thing in terms of admission, you and Leanne obviously are involved in helping us by making sure that the LSAT is accessible so that people can get past that first threshold on the way to law school. Once in law school, we do everything we can to make sure that our school, our community is as welcoming to individuals of all kinds, people with disabilities, individuals of different races and religions and so forth. Diversity, equity, and inclusion is a watchword for us, certainly at the University of Baltimore, and I believe in legal education generally. In terms of individuals who may want to work in this field, I'm very proud to say that at the University of Baltimore, we have a disability rights clinic. So we are affording students the opportunity to practice in this field of law, even while they're in law school under faculty supervision. And we certainly work with organizations in our community, for example, Disability Rights of Maryland, to provide internship opportunities and ultimately employment for people who choose to enter this field. This is fundamental to who we are as a law school, and I think I can speak for deans generally to say we welcome individuals with disabilities. We do our best to ensure that the education is fully available, and we then help people start that journey to practicing law, including in the field of disability rights.
Thank you so much. And I certainly, from my perspective, agree wholeheartedly with you. I've seen such a an openness and an eagerness to learn and to really open the doors of legal education wide. So I really want to encourage candidates to reach out to us, reach out to the schools of interest, to the deans, to the admission offices, and people really want to help you individually to make a successful journey.
Kellye?
Peter, I want to come back to you. You mentioned in your first remarks, and a number of our speakers have referenced it, this idea of a culture of accommodation, which is a great great framework. And how should, for those organizations that want to create that, what are some of the principles there? How do you do that?
Well, let me be a good lawyer for a second and not answer your question first, but be a foil. I come from Syracuse, which has a very strong commitment to these issues. We have a dean who started, Craig Boyes, who started an online JD program, which is taking off, which is grappling with a lot of these issues, but in a very respectful way to the other deans. There is still a terrific lack of information in academics. For example, there is no research that I'm aware of that suggests that just because somebody gets an accommodation, it's somehow an advantage, and somehow they won't be able to take the bar or won't be able to be a judge. This is a person, I work with Chuck Ruff. I worked with Stan Hare at the Baltimore Law School and go way back. There are fundamental misconceptions by deans and others across all walks of universities, coming from the United States Supreme Court, where in the most famous case, the PGA versus Martin, where Justice Scalia dissented and said, well, let's just give all the little leaguers with learning disabilities 4 strikes instead of 3, and then they'll all be able to play. This misses the point. There is no evidence that an accommodation for an otherwise qualified individual in any way unevens the playing field. There is no evidence that people who have accommodations in law school are going to have a tough time taking the bar, because that's not the way it is in real life. It's just not proven in empirical study. There are lawyers, forget about substance abuse and anxiety disorder and depression, putting that aside, whether you count that as a disability or not, which is probably half of the practicing lawyers to begin with. There is no evidence that people from the disability community with serious disabilities who otherwise can be accommodated can be any less effective in the legal profession. And among the worst purveyors, the worst promoters of this myth are faculty, law faculty, other faculty who say, well, this is my intellectual property, so I'm not going to record my class. Or if I change this somehow, it's going to make them somehow less of a good lawyer. And my point is that is antithetical, now coming back to your question, to a culture of accommodation. And I really believe, however nice we may be talking now, and these deans are all exemplars, and so is the LSAC trying to do the right thing, there exists an underlying and pervasive bias that somehow, perversely, disability is not only not entitling, but at the same time, somehow people are getting an advantage. And until we get away from that attitude, whether it's in regard to race, gender, or any multiple category, we will have a hard time creating a culture of accommodation. At my law school, which is, I like to believe, an exemplar, and the other law schools that are represented on this. And that is why, last point, the percentage of people with disabilities in the legal profession have been and remain less than 0.5%. And until we come to grips with that huge workforce that's possible, blindness, depression, mental health, underlying health conditions, pick any one, we will still continue to be talking about these issues 10 years from now.
Peter, that's a really important
fire.
point. That we have a lot of work left to do. And that's something that I know that we're really committed to trying to find ways to enhance that education and to build that understanding. Michael, I want to come to you because I know you've no doubt run into exactly that same bias in the work you do. What are some things we can do to build the pipeline better and to advance education in these critical realms that Peter points out?
Yeah, thank you, Kelly. And I have to go after Peter again. Um, these are all really important issues. I think let me pick up with the thread that Peter left off on, which is the abysmally low rate of lawyers with disabilities who self-disclose. Law is essentially a service profession, right? We serve other sectors of the world, and law has a particular social justice dimension where we're in an unequal world, and the job of lawyers is to help make it more equal. The system of having lawyers who are in the service profession works best when the bar is made up of individuals that reflect the communities they serve. And I think legal education over the last several decades has made tremendous strides, although there's lots of work to do on improving the pipeline of individuals to go to law school. I do think the biggest glaring omission has been the pipeline for students with disabilities. It is a huge problem. That's why I'm particularly proud of one program that we've set in place at Loyola through our Coelho Center. We created, and just last year had the inaugural class of what we call Coelho Fellows. I just attended the virtual graduation last weekend. It was awesome. What this is a cohort of undergrad students with disabilities with an interest in law school. And we bring them out to Los Angeles when it's safe to do so for a intensive week-long boot camp. We give them a year's worth of programming, different programming each month. We give them a mentor. We try to grow their awareness of what it means to go to law school, what it means to succeed in law school, and build their capacity should that be their choice, should they decide that they ultimately do want to go to law school. It's a phenomenal program. We're very proud of it. And again, it is a way to grow that pipeline which needs help. I think to pick up a thread that was talked about earlier, in terms of work options for students with an interest in disability law, if you are a law graduate with an interest in making the world more just, there's a lot of work to be done. And disability law, like other fields, is absolutely no exception. But I do find that I heed the advice that was given to me by Peter and I's dear friend, Chuck Siegel, when I'm advising students with disabilities. Part of what I say is, to the extent you want to go into disability law, that's great. You should. The world needs you to be out doing that work. You have a life experience that's incredibly important. To the extent you want to go to a law firm and make a lot of money, that's fine too. The world needs all types of individuals in all kinds of advocacy, and not every student with a disability should feel that they need to go into disability law. It's okay to go to a law firm and make a lot of money as long as you donate some of that money back to your law school. But we can talk about that later. In terms of what schools can do better and must do better, certainly the list is long. I know from examining our own practices and looking for things that we can improve on. And I think this is certainly something that is probably reflective of most law schools. One, on issues of accommodation, really having a meaningful check-in on the customer service aspect of that to make sure that we are not discouraging accommodations, that we are making it comfortable and painless for students to engage in that process, and recognizing that for applicants, for students, their time and energy are precious commodities, so being respectful of that. Part of it is communication, making sure we are being transparent and clear about what we should do. I have started, as part of my orientation welcome to the entering classes, spending time on this issue and saying, we know that some of you need accommodations, and that's fine. That's part of who we are to law school. It is always better to front load those requests than wait until the first round of exams comes out when you've tried to make it through somehow without accommodations. It only gets harder. So it is fine and acceptable, and you should engage that process now. rather than kind of ignoring it, brushing it under a rug. And that message has to come from leadership at the highest levels. Part of it, as Peter mentioned, both outreach, making sure that our professionals in this area have access to training programs, but also that we're creating education opportunities for ourselves, bringing in outside experts to help move faculty along from viewing this as a challenge to rather something that is reflective of the type of law school that they want to be at. So there's a lot there, but again, thank you for the opportunity to talk about these issues.
Well, thank you, Michael. Those are all great tactics and ways that we can make progress in this area. I want to ask Leanne one question before I turn it to Ken to go to our audience questions and the time we have remaining. But I just want to ask Leanne to follow up on anything that Peter or Michael have said that she'd like to emphasize about how candidates can navigate this environment as we all continue to make the progress that we know we all need to make together.
Yeah, I think those are very good points. I think, implicit bias and explicit bias is alive and well, not only in law schools, but in a lot of parts of society. And I think Michael's comment about education, and communication are really key. When I was a general counsel at a university, I worked very closely with our disability services staff to educate faculty on their obligations, one, under the ADA to accommodate students, but also to help them understand that they aren't giving these students any added benefit over standard test takers or students who are not being accommodated. These students genuinely need accommodations to put them on a level playing field. And ultimately, I think a lot of those professors came to understand that, but it was a learning curve for a lot of them. So I think at the law schools, you need folks who are advocates for your accommodated students to help them understand that these students aren't trying to get an advantage over non-accommodated students. They're really trying to be put onto a level playing field. So I would encourage you to bring in speakers, bring in advocacy groups, help your staff and your faculty understand, one, their obligations, and two, the real need for them to be sensitive to these individuals. And there are a lot of very helpful organizations out there. I've done outreach with a number of very helpful organizations, including Tony Coelho, who is the certainly the director and chair of the Coelho Center. I've interacted significantly with the National Federation for the Blind, trying to listen and learn about the challenges that students have so that we can better serve these students and better serve society by increasing our pipeline for candidates who have disabilities. It's very important. We've also worked very closely with the ABA Commission on Disability Rights, and we have a number of projects ongoing with them. And I think the more that that law schools and law faculty and deans and associate deans can become familiar with organizations that are advocates for disability rights, the better they'll be able to understand and be supportive of their students who need their support.
Great, Leanne. Thank you for that. And this reminds me so much that, all of these quests for equity, they're never done. It's like pushing a boulder up a hill, and the minute you let go, it falls back. That's how structural inequities work. So we have to all stay on it and stay aggressive and affirmative and in working together. And I've really enjoyed too the points that both Peter and Michael and Ron have all made about the intersectionalities of this issue. That it's often compounded with race, with age, with other kinds of things too that make it more complicated. Well, great starting set of comments, Ken. We don't have a lot of time left, but I know there's been a lot of audience questions, so maybe pose one or two of those for our panel and before we run out of time today.
Yeah, absolutely. Great discussion by our panelists, and we have 65 questions. So over the next 10 minutes, let me at least pose one to each of our panelists. And Leanne, I want to continue with you and ask you really two things. One, when students apply to law school, should they disclose disabilities? Should they disclose that they will be requesting accommodations? And then secondly, when they move from going into law school to starting the state bar process, we know that different state bars will ask questions about treatments that students have had. How do students navigate the state bar questioning, again, which varies among 50 states?
Yeah. Well, in terms of whether students should disclose that they have a disability for which they may or may not need an accommodation, I would say no. There's no obligation to disclose in the admission process. I think, but what you would want to do, as I think Michael talked about, is early in the process, after they've been admitted to law school and early in their class, at the beginning of their classes, they should go to the disability services offices, let them know that they have a particular type of disability and that they require an accommodation of X, Y, or Z. They will then engage in an interactive process with that disability services office, and the faculty member doesn't even have to know that they have an accommodation necessarily. So I would not disclose a disability on your application. You have no obligation to do so, and the law schools have no legal right to ask you to do so. The second question about the state bar process and whether you should disclose that you are being treated for a particular, what could be perceived as a disability, that's a really difficult question, and that's mainly governed by state law, the bars in those states. So I can't really give a blanket response to that. I think you should be cautious about how you respond to that. But remember that the bars cannot discriminate against you based upon any real or perceived disability. And if you believe that that's the case, and I know there have been a number of challenges, then you have a number of disability rights groups that you could go to get some support.
Great. Wonderful advice. Thank you.
Sure.
Peter, I want to turn to you, and the field in which I work now is online, and you mentioned online. Of course, Syracuse has been a leader in online education. Do you think that because of the move to online, we'll see a general accommodation for different kinds of education? I mean, one of the reasons why legal education often has been pretty conservative in changing, it's that people are supposed to all be positioned in one way. What do you think the impact of the current situation will be on an appetite, receptivity to online education?
That's an excellent question, Ken. And we are at a transformative point. I was thinking as Leanne was talking, I was going to call her Sisyphus from now on. And I was thinking, Leanne and Kellye, do you want to be pushing that boulder up that hill for the next 10 years or the remainder of your career? Or is there another hill, another way to think about your business? Now, this week, of course, we know the University of California, Janet Napolitano, said, don't croak anything, but no more SAT and ACT in the California system. So what's the LSAC's business? Is it the LSAT and bar prep? I don't think so. You guys are really wise and know what you're doing. What is the LSAC's place going forward, and how can it be more inclusive than it traditionally has been? And does that mean, as you're saying, Ron, a different way of thinking about this endeavor? Does it mean that we think about research which basically shows that no matter how much time you give anybody, it really doesn't change the scores, and there's really not so much time pressure in legal practice as the myth may be? Yeah, of course, if you're a litigator or doing a corporate deal, I mean, I practice, others practice. There are very different ways of practicing. You're not always under great pressure. Now, we're in a different business model today, certainly of legal practice, so that may cut differently. But I guess I would say, not meaning to be glib, why don't we rethink, or you guys rethink together, what business you really are in and where you want to position this organization 10 years from now? Do you want to keep pushing that boulder up the hill, Or are there new ways with law schools, whether it's online education, which I think will be a hybrid in the future? I think certainly the face-to-face is crucial, but I think the Syracuse model, as Dean Boys is pursuing, has shown terrific promise, and I direct you to speak with him. And this time gives us that opportunity to think, because we will not be going back to the way we were. We will be going forward to a new normal, which will involve whole new conceptions about what accommodation means in work and life. I don't mean to wax too philosophical, but I do mean to suggest that why are we having this conversation 30 years after the Americans with Disabilities Act, and we don't want to be having it over the next 10 years?
Wonderful. Great insights, and we wish we had longer today to pursue that. I'm sure Kellye and Leanne have reflections on that as well, which we should follow up. But in the remaining couple of minutes, I'll ask both Ron and Michael sort of a dean question. Ron, we'll start with you. Law schools put courses online really quickly when COVID-19. I actually think we're doing more remote teaching than we're really teaching online. We're more teaching remotely. But when your faculty or faculties generally thought about moving to remote or distance education, what kind of considerations, if any, were giving to students who were facing challenges or disabilities?
Sure. Let me first, if I may, associate myself with something Peter said, which I think is so important, that accommodation should not be about anybody getting an advantage. It's about leveling the playing field, making sure that everybody has an equal opportunity to succeed. And that's why I think that accommodations need to be the product of this interactive, individualized process, and that they're empowering. We want to empower students to succeed. And we need to serve the full student, the whole student, not just a doctor's note, but the full range of circumstances in a student's life. With respect to online education, as you say, Ken, for many of us, it was very sudden this March when we moved to an all online format. And I think we saw a lot of challenges. Michael said earlier that this new modality lays bare vulnerabilities of our students and of our program. And I think as we look ahead to the fall, and we know we're going to be engaged in more distance education, we need to be sure that no student is left behind. In some ways, the online format opens things up for students with disabilities. Asynchronous education allows people to work more at their own pace, but students can get lost behind the screen, and we need to make sure that we're in touch with our students and serving them in every way that they need to succeed.
Wonderful. Thank you. Thank you. Thank you for connecting it to Peter's comments. And Michael, I'm going to ask sort of a final question. Law schools everywhere, along with universities, are making plans for the uncertain fall, right? Thinking about hybrid or blended and all kinds of scenarios. What special consideration should law school deans be thinking about this summer for that contingency planning for the particular community of individuals facing disability?
Yeah, it's a great question. Thank you, Ken. And you're right. We're all, necessity is the mother of all invention. So we're all, pushing our creative and innovation buttons, even harder than we have in the past. I hearken back to the advice of my friend. A lot of people have said this. The voice in my head is Peter and I's friend and co-author Eve Hill, which is when you are building something new or creating a program, unless you are thinking about the needs, in this case, of individuals and students with disabilities from the ground floor, you're not going to get it right. You're always going to be playing catch up, whether that's technology or anything. So it's making sure that in any program or variation of a program that we put together, we are challenging ourselves, how is this impacting and how will this work for all of our students to create that kind of model of inclusiveness that Peter's talking about. But the one thing we know is if you don't think about it from the very beginning, it won't happen and you'll be breaking things and playing catch up.
Wonderful, thank you. We're about out of time. I'm going to turn it over to Kellye for some closing remarks.
Thank you so much, Ken. And I want to thank all of our panelists again for a really wonderful and thought-provoking panel. I learned a lot, and I'm sure our viewers did too. And I think that one of the things that we all can see is we've got a lot of work to do. To answer Peter's provocative question, we're so eager at LSAC to continue what's been our longstanding devotion to equity. And that's going to take innovation. I agree. And it's going to take collapsing the time between learning and assessment and understanding those things can go together. They can be holistic, and that every person deserves to really be seen in all their complexity and to have an opportunity for learning and to make a contribution to this world. So that's certainly what our focus is going to be. And we look forward to partnering with everybody to find the ways to do that. Sometimes we can agree on what we want to do and finding how to do it so that people aren't judged by just where they went to school or who they know. That's so critical. So I want to thank everybody for being with us today. Thank all the viewers. Please remember that you can see this again if you look at lsac.org or at iLaw's website. And please let others know that may be interested in it, that it's there for them to consult. I know that this group that's been with me today will all keep working hard to advance equity in law and in education. And I hope all of you will tune in with us in the future for Live with Kellye and Ken. We're going to plan this summer our 2-year anniversary show to really call out an important summit on legal education and see where we all are then in terms of the return to the campus in fall or how that's going with more remote learning. So we'll be in touch with news on that, but we really thank you for being with us. Ken, it's always a pleasure.
Thank you, John.
Again, panelists, great job, and let's keep up the great work together.
Thank you.
Have a good day, everybody.
Thank you.
Right.
Thank you.